Your patents suck because you're not leveraging the power of continuation practice. Part 2. Hi, my name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please do me a favor and follow and share. In the last video, we discussed two big things that you can do with continuation practice. And we're going to discuss the first one in more detail. That is, you can pursue broader or better claims while still getting a patent on some claims that were previously allowed. Now, what am I talking about? Well, sometimes what happens when you're prosecuting a patent application is you'll get to a point where the examiner agrees with you that certain narrower claims are patentable. And so the examiner will indicate that those are allowable, but he or she will still continue to disagree on certain of the broader claims and will reject them. At that point, you can argue for the allowance of the broader claims within that patent application. But there are two drawbacks to doing that. The first is the examiner could reconsider the decision of patentability on the ones that he or she previously said were allowable. They could change their minds. There's no estoppel for an examiner, so they could do that. If you just take the allowed claims by canceling the ones that were rejected, they're very unlikely to reconsider their decision. So it's a much more certain path to a patent, albeit one with narrower claims than you want, but you'll still have some protection. You can say your product's patented, you can put the patent number on it, etc. The second thing, though, is that if you don't make any arguments about the other claims, you have a much cleaner file history, and it will be much less likely that an infringer will be able to try to use anything you say in the file history against you in a litigation proceeding, either for purposes of limiting the claims through claim construction or limiting the scope of available equivalence in the doctrine of equivalence. And a clean file history is a nice thing to have when you're litigating a patent. Remember what I said before, the patent law, Miranda rules, anything you say in the file history or anything you say in the patent office can and will be used against you in a court of law. So there is definitely a benefit to having a clean file history. So that's the first big benefit. What you do is you cancel the rejected claims in the original application, and then you file a continuation application and resubmit the broad claims you wanted in the first place. Now, you'll probably get the same examiner, and you might get jammed up again, and that examiner might not allow those claims. So you ultimately might have to file an appeal if you ever want to get those broader claims. But the point is, it gets you a patent sooner and more surely than if you fight in the same application for the allowance of the broader claims. So tomorrow or in the next video, we'll talk about the other key thing you can do with continuations. I hope that helps to keep you out of trouble, and I hope to see you here soon.